Thank you, Mr Speaker. Mr Speaker, Part 2 of the bill, which has just been described by the Minister, contains some quite sensible provisions. But because of the appalling provisions in Part 1, there's no way that Labor can support this legislation, because with this bill, Sir, the National Act Māori Party Peter Dunn government leads us boldly back into the 19th century. We go cringing back to our colonial origins. And yes, fingerless gloves would be in order, sir. The Attorney General was the original sponsor of this bill, although I see mysteriously it's been taken over by the hapless Associate Minister of Justice, Nathan Guy, who's just read the notes that have been provided for him by the Ministry of Justice on the bill. It was a very good recitation of the departmental speech notes. But it is interesting, first of all, to pose the question why Chris Finlayson is no longer the sponsor of this legislation. Does he want to avoid the suggestion of a conflict of interest, having returned the nation to this cringing colonialism and this return to QCs, so that when eventually he procures his own appointment to the rank, he can't be accused of some sort of conflict of interest? Just as the government has restored knighthoods, just as this government has restored the title the Right Honourable to the 3 senior officers of the state, a total constitutional nonsense, given that they're not members of the English Privy Council. They're just holders of this redundant title in this country without any meaning whatsoever. Maybe it'll be good for the odd upgrade on a plane when they're retired from this place, but that's about all it means. And I see Mrs Collins responds well to the idea of an upgrade. But the House needs to ask the question, how can we be taken seriously? How can New Zealand be taken seriously in the world as a multicultural Pacific nation, while we have this government so addicted to colonial cringe? And I have to say to Nikki Kay, this isn't going to go down well in Auckland Central, Ms Kay, because people in Auckland Central are really proud to be multicultural, really proud to be part of an independent country in the Pacific. And here we have this government going back to this colonial cringing. We have to have our historical links to the Crown recognised. We have to have English titles back. We're not good enough on our own. We have to have Queen's Council. We have to have knighthoods. We have to be Privy Councillors. It's just appalling. We can't have the external trappings of an independent state. We have to, under this government, go back to the old colonial titles. We must be the only place on the planet that has not only that has abolished colonial titles like knighthoods, privy councilorships and Queen's Council, only to actually restore them, in this case by legislation. Mr Speaker, it's bad enough. It's bad enough that we're going back on this cultural cringe trip, that Nathan Guy's been put up to this job by the Attorney General, so the Attorney can have this coveted title of Queen's Counsel at last, so long denied him. But worse than that, the justifications that were advanced in the Associate Minister's speech, which he read so diligently just now for us, just don't stack up. As I say, let's put the colonial cringe arguments aside. It's said to be all about preserving the independence of the legal profession and correcting what is said to be an overly rigid approach to the appointments process for senior counsel. Well, sir, there's nothing in the independence point. Absolutely nothing whatsoever. And the proof of that is in the fact that the Minister conceded when he read the notes from the department that actually the Governor-General retains a discretion here to appoint members of the legal profession from law firms from time to time to the rank of Queen's Counsel. There'll still be the ability to do that. So where is it provided in the legislation that independence will be preserved if this extraordinary power continues to exist? It just proves the lie in the argument. But, sir, the appointments process and the rigidity that is said to exist in it is also a complete nonsense. What I want to do is read into the record of the House something that was said in 2003 by one of New Zealand's leading litigators, Jack Hodder, who was a barrister, a law commissioner, now a partner in one of our major leading law firms, and incidentally, somebody who happened to be one of the inaugural appointees to the rank of senior counsel, though at the time he couldn't have known that would have been in the offing. This is what Mr Hodder said about the appointments process, which we're going back to, for Queen's Counsel. This form of state patronage perpetuates a misleading and damaging two-tier perception of the legal profession. It empowers the state apparatus, currently the Attorney General and the Chief Justice, to discriminate between lawyers, advantaging some and, by implication, damaging others. All this is done under a secret and non-accountable process. That process cannot be sensibly reformed. The current and future holders of the offices of Attorney General and Chief Justice should not be distracted nor placed at risk of charges of favouritism by involvement in such a process, in which they must rely on secondary sources. The critical independence of the legal profession can only be impaired by any such selection process. So, sir, the truth of those words is manifest. Quite the contrary to enhancing the independence of the legal profession, what this legislation will do is take us back to a system where the Attorney General and the Chief Justice, from time to time, under a secret process, relying on secondary sources, can elevate some members of the profession to exalted status, enable them to charge more money than they could have done by way of fees previously, and all this is said to be somehow enhancing of the independence of the legal system, when in fact it will actually produce the opposite result. So the other interesting observations that were made by Mr Hodder in his independent article are as follows, and I agree with them, and I want to make sure that the House does take note of them. First of all, the rank is of no assistance in maintaining or enhancing professional standards in the practising legal profession. The rank is not well understood by the public. Indeed, it implies quite incorrectly that the beneficiaries of the rank are able or entitled to advise or speak on any legal matters with greater authority than others. The rank creates an unnecessary and unhelpful division between those few favoured with the rank and the rest of the profession, who are implicitly and sometimes explicitly relegated to junior rank. For nearly 90 years, only a fraction of the New Zealand bar has been able to apply for the rank, the vast majority being practising in the fused profession as barristers and solicitors. The rank has not been available to leading lawyers who practice in areas other than advocacy. The rank represents characteristics of the legal profession of England and of the past which are damaging to the New Zealand profession of the 21st century. Adherence to archaisms, retention of elitist divisions, secret procedures and a mistrust of market forces are all hallmarks of the rank. And finally, the rank is not necessarily reliable as an indicator of skill as an advocate. While the current leading QCs are among the leading advocates in the country, there are advocates in law firms who are their equals, and there are QCs who are at best marginal candidates for any leading advocates list. Sir, this is bad law. It does represent a colonial cringe that many of us thought we'd grown out of in this country, but clearly the results of the actions of this government show that we haven't. It nullifies all the attempts to harmonise with the Australians in the legal market. The Australians have done away with this rank in all but one jurisdiction, and they'll laugh at any jurisdiction that actually goes as far as restoring it. Sir, this is bad law. It's bad for New Zealand. It's elitist, and at the earliest opportunity, a future Labor government will repeal it.
Paul Quinn.